Good afternoon, everyone, and good morning to those of you on the West Coast. Welcome to our program entitled Nonprofit Contracts, Best Practices, Negotiation Strategies, Practical Tips, and Common Pitfalls. My name is Jeff Tenenbaum. I'm the chair of the Nonprofit Organizations Practice at the Venable Law Firm. As many of you know, because I see a lot of regulars here, this program is part of our monthly series on nonprofit legal issues that we host here at Venable, both here in person and a webinar component for those around town and across the country that can't join us here for lunch. We hold these from 12 to 2 p.m. Eastern, with the program starting approximately 12:30 Eastern, and we try to cover a wide array of interesting and hot-button and useful nonprofit legal topics, and hopefully we're doing a good job. We are now past our one-year mark of doing these programs, and hopefully you've enjoyed them as much as we have. Today's topic is one that is probably as basic and bread and butter as it gets in terms of nonprofit legal issues, perhaps not one of the sexiest issues we've ever covered, but perhaps the one that has the most relevance to us and to so many of you that work in and for nonprofit organizations. I've been practicing law for about 17 years, and I cannot even begin to count how many contracts I've reviewed over the years. And I know for George and Audra, our speakers here today, it's quite the same. Hopefully through that process, we've learned quite a bit in terms of all different sorts of legal contracts. A lot of tips, a lot of pitfalls, a lot of things to use as best practices, a lot of helpful negotiation strategies, and certainly a lot of pitfalls that our clients have fallen into. And we're going to do our best to try to relay all that to you today. We're not going to focus on any one particular type of contract, and hopefully the wisdom that we'll try to impart to you here today will be broadly applicable regardless of the type of organization you have or the type of contracts that we're talking about. We're fortunate to have two terrific speakers with us here today. To my immediate right is George Constantine. George is the co-chair of Venable's Regulatory Practice Group and a longtime leader with me of our nonprofit practice. George and I have been practicing together at Venable for quite a number of years. We're both alumni of the American Society of Association Executives, where we both worked prior to coming to Venable. And George, like I said, is as bad as experienced as they come when it comes to nonprofit contracts, and is also very gracious in that he is pinch hitting for our colleague Lisa Hicks, who had a family emergency and had to be out of town. Was supposed to be our speaker here today, but George is going to ably fill in and will certainly do an outstanding job. To George's right is Audra Hegney. Audra is an associate in our nonprofit group. Joined us, about 2 years ago? Yeah. Almost a year. Seems like 2 years. As you can tell, she's become an integral part of our nonprofit practice very quickly. Audra is terrific to work with, extremely knowledgeable, works on many, many, many contracts for our nonprofit clients, and we'll have a lot of interesting things to say to you here today. A few logistical issues. First off, as always, we encourage you to ask questions throughout the program. For those of you here in the room, ask questions by raising your hand, and I'll call upon you. George and Audra will be going back and forth, so those might be maybe the most appropriate times to ask your questions as they're switching back and forth, but feel free at any time. At some points, if we have too many questions, I may need to cut things off so we can be sure to get through the program. For those of you on the webcast, and we have about 200 folks on the webinar here today, so we have a terrific crowd, about 100 of you here in the room. For those of you on the webinar, ask your questions using the chat feature on the webinar. I'll be manning the laptop at the front of the room, and I'll pose those questions to our speakers at appropriate times. For those of you here, you have copies of the PowerPoint and some ancillary materials, a bunch of articles that we've written on different nonprofit contract issues. For those of you on the webinar, you should have gotten in your confirmation email a link to those materials. As always, tomorrow we'll be sending out to all of you, both here in person and on the phone, a follow-up email that will contain a link to the recording of the program along with a PowerPoint presentation and handout materials. You can feel free to share that with your colleagues and others who may be interested. So, of course, we are recording the program. And as always, we post the recordings of all of our nonprofit legal seminars on our website. If you want to go back and listen to any of those along with the PowerPoints at venable.com/nonprofit/recordings. Finally, all of our upcoming events you can see posted at venable.com/nonprofit/events, and all of our publications, articles, PowerPoints are available at venable.com/nonprofit/publications. All of those links are at the tail end of the last slide of the PowerPoint presentation. Plug for our three upcoming scheduled programs that we have. On June 13th, we're going to be doing a program entitled 10 Best Practices for Protecting Your Nonprofit's Intellectual Property. On July 12th, we're going to be doing a program called Nonprofit Chapters and Affiliates, Key Legal Issues, Pitfalls, and Successful Strategies. And on August 2nd, we're going to be doing a program called How Nonprofits Can Raise Money and Awareness through Promotional Campaigns Without Raising Legal Risks. Those are all listed, by the way, on the second slide of the PowerPoint presentation if you need that for reference. I want to thank, as always, our very able staff person, Jamie Fitzsimons, who does a terrific job in organizing these programs. And with that, I'll turn it over to George to get us started. George.
Thanks, Jeff. Good afternoon, everyone. Thanks for coming today. Audra and I have a few slides we want to go through. We're going to bounce back and forth a little bit, try to keep things lively, and we'd love to hear your questions as they come out. As Jeff said, there are a lot of different types of contracts that we could talk about, and we're trying not to focus on any one type. We do have a section we're going to talk a little bit about meeting contracts, and so many of you are interested in that, but it won't take up very much of our time. So hopefully we'll get to what you were hoping to learn in our prepared remarks, but please feel free to ask questions as they come about, and I know we'll be getting some questions on the web function as well. Just to give you a little overview of how we're going to structure this, I'll talk briefly about some contracting trends that we've noticed kind of anecdotally working on reviewing contracts for our clients over the past few years, identifying the risks that are involved. We'll give some more kind of non-legal but negotiating tips for negotiating agreements, talk about some key provisions, delve into that somewhat deeply as to what are the more important legal provisions in your contracts. Then talk about some management issues as to how to manage your own contracts as a nonprofit organization, association, what have you. And then we'll conclude with what we think are the top takeaways. As Jeff pointed out, we do a lot of contract review here at Venable, but we also know that a lot of our clients and a lot of organizations won't send every single one of their contracts to outside legal counsel for review, much as it is to our chagrin that we don't get every one. There are going to be agreements that are reviewed in-house. You may have in-house counsel, or you may just not have the capacity to pay for an external review of every contract you receive. So we're doing this from the perspective of our understanding that is the case, and so we want to help to the extent we can in those situations, and maybe point out those areas where legal review or legal consultation is necessary or appropriate. This trends that we're talking about here, I'd say, treat this as our anecdotal experience, and we have done a number of these reviews, and this has kind of been our perspective. And in talking with you and other folks in the community who work for nonprofit organizations, we've seen perhaps with the economy's downturn a kind of decrease in the tolerance for risk or taking on new responsibilities from an organizational perspective. And as such, there's been a push for renegotiating even long-term relationships. From the sitting in on board meetings and hearing the discussions that take place there, there's a lot of awareness of and concern over, whether we are truly getting the best deal, and a tremendous, I think, move towards focusing on data and the importance of making fact-based decisions. And because we've always done this, or because this is a great partner that we've had for years, isn't enough anymore. And frequently the board will say, and maybe even impose a policy on the organization saying, after a certain number of years, your relationship with this or that vendor needs to be reviewed, an RFP needs to be sent out, we need to get bids, and we need to make sure that we are getting the deal we think we're getting, and make sure we're getting the best thing out there. So there's this pressure on, from a management standpoint, to renegotiate even long relationships. And there is, I think, an increasing concern over not taking on risk unnecessarily, and therefore getting more legal review of agreements as they come about. Obviously, pressure on costs. What are we paying? And a lot of that drives a lot of, what we're going to talk about today. We found that in-house counsel and indeed staff without in-house counsel are being pressed to do a lot more with less. We know what the conversations are around budgets on that front too. So what does this mean from a contract review perspective? What can a contract review achieve for you? Well, the number one thing you're supposed to be doing is identifying risks, be it financial or legal, in the contract. And the first question when you look at an agreement is, does it spell out exactly what the obligations of each party are? We'll go into deeper dive as to how to make sure that we really have a good understanding, particularly on the other side of the table, as to what the other side is saying they are going to do for us. Most of the agreements that nonprofit organizations work on that we see are ones where the service is being provided by someone else to us. We're paying for a service. We're paying for a product. It's not unusual to see the other side. It's just less frequent where you see a situation where we're providing a product or service to the marketplace and writing a contract for that. We're going to address it from both perspectives, but I will say from the perspective, the usual perspective of us paying someone to give us their service or their product, the obligations of the parties, the number one most important issue to identify at the outset and make sure it's clear. Another kind of big picture issue to look at from the risk perspective is what I call special issues that are of particular importance to the nonprofit community. We talk, in the world of contracts, there are some key issues no matter what type of organization you are. But as a nonprofit, we have tax-exempt status, or largely most of us do have tax-exempt status, and therefore we owe a certain obligation to make sure our activities and the engagements we enter into are consistent with that status. Think about particularly those revenue-generating opportunities that we'll often enter into as organizations from the royalty perspective, sponsorship perspective, also joint ventures. Those sorts of activities where we're contracting with another entity, and particularly if it's a for-profit entity that's out there, is going to necessarily raise tax exemption tax issues. And I'm happy to talk about specific ones as we go through this, or if you have questions that arise. But from a big picture perspective, when you're looking at your contract, and even before you get to the contract, when you're looking at a particular activity that you're contemplating undertaking, that's one of the first considerations that needs to be at the forefront of your mind. It's consistent with our mission, it's consistent with our tax-exempt status. Similarly, particularly on the trade association side, antitrust issues can be extremely important and fraught with risk if not addressed. Take, for example, a trade association that wants to get in the business of publishing statistics from the industry. Well, you may just view that as a contract with a service provider that's collecting that data and then redistributing it out to your members and making sure that that's done efficiently and effectively at a low cost. But you also have to remember a very significant consideration that if that's not done properly, there are antitrust risks to the association and potentially each of your members. So things like confidentiality and how the data is going to be safeguarded will be very important in a contract like that. Finally, regulatory issues. As nonprofit organizations, we have a certain sphere of regulations that apply to us that may be outside of the tax world, which we just talked about, but also charitable solicitation registrations, or are we engaging in a commercial co-venture activity that may bring on state filing obligations. And if you're an association that's in a particular industry or profession, or you're looking at a contract saying having to do with insurance, you may be state regulation of insurance issues that come into play there too. So, we're talking about some big picture issues that are outside of the normal consideration you might think falls into the contract world. And when we talk about these risks, and we talk about as we go through this process, one of the key things that we ask our clients, and particularly if you're going to review this in-house, to consider is that in a way you're in the role of an issue spotter when you're looking at the documents and when you're considering a particular activity, whether the organization should undertake that activity. You're not being asked to be the tax exemption expert or the antitrust expert, but you need to know enough to know when to ask someone who is. And so a lot of what we're talking about here isn't necessarily to get steeped in the regulations of the Internal Revenue Code or understand the cases under the Sherman Act, but rather to know where there is a concern and where there is an issue and where to go to the right person to get the answer. And I should have said at the outset, a lot of this may be, as Jeff said, a very basic set of issues that we're talking about. And for going over some of these basics, for some of you may be repetitive or something that you've heard before, but I think it forms a good basis for the more in-depth discussions we'll get to later in the program. And nonetheless, everyone can use a good refresher now and then too. Having said that, some of the basics of contract drafting and negotiation, one of the kind of cardinal rules of contract from a legal perspective is what's often referred to as the four corners rule. When courts look at a contract and look to decide who's right on a particular interpretation issue, they look to the four corners of the document. Anything that's inside those four corners applies. That's part of the contract. The court doesn't want to hear about what you said in negotiation phase. The court doesn't want to hear about what this or that side communication was. If it's in the document, if it's in the contract itself, that's what the court is going to interpret. And if that's clear and unambiguous, the decision's easy. It usually won't even get to a court. So when we talk about the importance of these provisions and getting it right, there's some real consequences if you don't. If it is ambiguous, if it is unclear, then you're in a position where there's a factual interpretation that takes place, and seldom does it end out clean or to the organization's advantage when the contracts are unclear. Oftentimes there's some back and forth and posturing with contracts disputes, and we've been part of that. Probably helped cause some of that from time to time, but the reality is, these contract disputes largely end up getting settled without getting to a court decision. So there isn't a whole lot of, grand case law for us to rely on when it comes to contract negotiation. Contract interpretation tenets. But nonetheless, there's enough out there for us to go off of. So one of the takeaways from this point that I think is very important, and those of your counsel in the room will probably nod your heads. Please don't force us to a one-page limit or a two-page limit on a contract. Maybe sometimes it's appropriate. Maybe sometimes what's at risk is so negligible that it's ludicrous to paper it over with dozens of pages. But if it's not in the document, then it's subject to interpretation. And when it's subject to interpretation, you're like tossing the dice. You don't have that comfort of knowing exactly where things are. So, I understand the need for documents to be legible and understandable and not, occupy too much of your time or our time to interpret. But by the same token, there are a number of key provisions that need to be in virtually any contract that you have with any of your partners, vendors, et cetera, and they won't lend themselves to a short limit. Of course, we could always do 3 columns and 6-point type. We've done that. Oh, a couple more things real quick. We're talking about written agreements largely here. It's important to know, again, from the very basic level, that a contract doesn't need to be in writing to be enforced and interpreted as being in effect. And it doesn't need to be in a document that says agreement at the top. And you can have a contract even if it says something like letter of intent or memorandum of understanding. In fact, you likely do have a contract in those. So it's not enough to kind of feel that unless we have this formal thing that says contract or agreement at it, that we haven't kind of reached that final phase yet. It doesn't matter what it's called. It's what's inside, what the actual text of the document is that's very important. In a real-world example, not too long ago, we had a client come to us with an issue with a service provider where they hadn't signed the agreement. We had not signed the agreement. And the service provider was still trying to charge us for the deposit fee that would have been owed had we signed the agreement. And the service provider was really digging in its heels on this, and we were kind of at a loss until we found out that the service provider had an email from a staff person at our client that closed with, "We have a deal, forward me the agreement and I'll get it signed." Now, that's not enough necessarily in the eyes of a court to say, you've just bound your organization, but it certainly created messier facts than we would have liked and put the organization in a less solid position than it would have been if that communication didn't happen. So it's important as you're talking as in-house counsel or a organization executives out there as you're working with staff. Email's a great tool, but it also can get you into a little bit of trouble. You have to be careful, particularly in contract negotiations, as to what is said and what isn't said. Some kind of yes, question.
Russell McKinnon, what if there's a verbal agreement, a contract, and what has to be in
The question is, when is a verbal agreement a contract, and what has to be in that verbal agreement to make it enforceable? The general rule is that there's 3 elements to any contract. There has to be an offer, there has to be acceptance, and there has to be some exchange of consideration. And that exchange of consideration can be a promise to pay, and the other side could be a promise to do services. So at the very basic level, if you have a person say to you, I will provide you, 20 widgets if you give me $10, and that person says, it's a deal, they shake hands on it, from a common law contract perspective, you have a deal, you have a contract. Now, there are a lot of courts will look to the prevailing usage or trends in the industry and see if there's, usually for something of this nature, that usually would require a written contract, that perhaps there was an implicit, understanding that this would be subject to an agreement. But the common law rule for contracts is very basic and very easy to meet. 3 elements. What I always counsel our clients and other folks when I've given these types of presentations in the past is, to get, a lot of times we're talking about a lot of different types of contracts. I'll use meetings as an example because a lot of the organizations in this room do a lot of contracts with hotels, with convention centers, meeting type contracts all the time, is to get your meeting planners to understand, some kind of, include some kind of basic disclaimer in their conversations, by email that, any of this, offer would be subject to approval by management or, something along those lines. In my mind, you go to a court with that widget example, it'd be very difficult for, someone to enforce that if there weren't any damages incurred when the other side tries to cancel, for instance. But I'd hate to even have those facts, if you know what I mean.
And this is Jeff Tenenbaum. Just to follow up on that, we've seen way too many situations where our clients get themselves into enforceable contractual obligations even though they never signed a contract and perhaps didn't intend to sign the contract. It can be through verbal exchanges, it can be through email exchanges, there can be a contract implied, and there's even a concept called detrimental reliance, which means if one party kind of takes an action because it was believing that the other party was entering into an agreement and then that party incurs some cost or incurs some harm, the other side may be liable for it even if no contract was ever signed. So I think the important lesson to take away from this is you want to be very careful to have good procedures in place, internal procedures, for entering into written contracts anytime you want to enter into some kind of obligation or purchase services or contract for whatever you're going to be contracting for. Have good procedures in place for having a written contract, have good forms that you start with, and have good sign-off procedures, kind of checklist that you go through so that you don't find yourselves in those situations. We've had too many situations where a client ends up getting obligated for a big cancellation fee or attrition penalties at a hotel when it never even intended to sign the contract with a hotel. But when you go back through the exchanges of emails, there was offer, there was acceptance, and there was some consideration provided. So you need to be careful.
Yeah, that was my second point, as a matter of fact. No, that's all right. Regardless of what your own policies are, if they're not enforced properly, and say a lower level employee signs on behalf of the organization, which is contrary to your policies, such as only director-level employees can sign an agreement at this amount or higher, but a manager signs it. If the other side has no reason to believe otherwise and is reasonable in its belief that this manager can bind the organization, it doesn't matter what your policy is, you're bound. Very important point to remember. Okay. Just a few more points, and I'll turn it over to Audra here. And we're kind of blending some of the legal issues with some of the practical negotiation and management issues, and it's based on our experience, and you may have some experiences to share as well on this front. So much in contracts, obviously, in contract negotiation is leverage. Where do we stand on the leverage scale, and what can we really drive from the other side? And so much of what we're going to talk about, even from the legal side, what kind of indemnification can we get? What kind of limitation of liability can we avoid? Is going to depend on the leverage that we have. One of the key things that we like to recommend, and we've got a lot of forms to do it with, is if you do have a certain type of contract that you enter into all the time, you use a lot of independent contractors to write your articles or to do photography for you or to do other sorts of things for you. Start with your form agreement. It's always a little bit of a leverage advantage to have your own contract that has your provisions in there, and that's what you're starting with. Sometimes more than a little. It's sometimes a lot of advantage. It's on the other side, not that great to kind of reach a deal in concept with a company or an independent contractor, and then say, okay, well, give me your contract. And you know what the next step often is once you get the contract that comes from the other side is, well, this is all standard, we can't change it. We'll talk about that nasty standard word, we don't like it. Really, do you really have to change this because I have to go to legal, and if I go to legal, it's going to take another 2. You've heard all of the objections before. It's so much better to start with our own contract, and not just start with a form that Venable or someone ships off to you, but know a bit about that form and know where the key points are and what the really important ones are and where the give points are in that contract. Another thing we're going to talk more about that's just very important, and if those of you, a few of you in the audience have participated in some of the presentations I've given in the past, so you've heard this before. The RFP is a great tool to take advantage of a leverage position that you have at that moment in time. And not to steal too much of Audra's thunder, but just think about it. You're looking for a 6-figure deal with a software provider, for instance. Your leverage is at its highest when the potential providers out there is the field. They want to stand out, they want to show that they're better, and they want your business. At that point in time is when you're at the highest, the peak of your leverage. Where you're at the lowest end of your leverage is after you've gone through a 6 to 8 month selection process, whittled it down from 10 to 4 to 2 to 1, had board meetings over it, had all sorts of discussion over it, and then you tell the organization that you've selected, we've selected you, now give us your contract. That organization is going to know full well that your organization wants nothing to do with revisiting that process again. They know that they're locked in and they can drive a hard bargain then. That's when your leverage is the lowest. So remember that, and Audra's going to talk more in depth about that, so I'll stop there on that.
Well, one ancillary comment there, that same principle, a lot of our clients fail to think about it in this way, but the same principle applies to executive employment contracts as well. We've seen too many nonprofits go through a whole search process for, say, a new CEO or another senior executive, go through the process, narrow down to their candidate, and then start to negotiate the key contractual terms with the candidate. Same thing like George just said in the software contract. Your leverage is at its greatest before you make that decision of who you're going to go with. Create your standard form CEO employment contract first before you select your candidate. Make clear to the candidate, which provisions are non-negotiable. Certain things like compensation and severance and whatnot certainly are going to be negotiable, but other things like non-competition or non-solicitation of employees or confidentiality or conflicts of interest may be really important to the organization. So nail those things down first, then start to work with your candidate. And I think the same principle also could be said that you want to always keep that secondary candidate, the one that came in second in your RFP process. Don't knock them out until the process is done, because a lot of times we see our clients select their preferred provider or their CEO candidate, and then they go through the negotiation process and they just get stuck on some really key deal terms and it just doesn't work out. You want to maintain your leverage by keeping that secondary candidate and using that candidate as leverage in the negotiation process.
That's great. Yeah, that's a good point. And then the last point I have on this slide, then I'll turn it over to Audra, is it may sound basic, but it's important to keep in mind. Be aware of the market you're dealing with. You may think you're getting a great deal. I say particularly with meeting contracts. Think about the geography where you're going. Think about just the market generally. How is it for meetings these days? Is it can we drive a 20% attrition deal, or can we drive a better bargain? Be aware of where the market is for whatever it is you're buying, and therefore you can kind of set a success goal that's kind of data driven, and based on the facts that are out there, as opposed to just this. In some years, this would be a great deal, but in a year like this year, we can drive a better bargain. So let's keep aware of that and make sure that we're attuned to what's going on in the market. Okay, I'll turn it over to Audra now.
So to continue on George's very good points about the RFP process, this is something that we really do recommend, and it really does help to make your approach to contracting more formal and more professional. And what this really helps your association do is to specify up front all of your requirements and your expectations for any sort of service or good that you're going to be soliciting RFP responses for. And this is a good time to really take some time to develop your RFP. Think about your budget. Think about your expectations, your timeline. All of those things should go into the RFP. And then you should circulate it to a very wide audience to get responses for that. And as George mentioned, this is a time where you have great leverage. Everyone that's responding knows that all of their competitors are also going to be submitting responses to your RFP. So this is when you want to not only include in your RFP your specifications, your timeline, your budget, but you also really want to think about the contract and what you want in this contract. And it's perfectly permissible, and we recommend that you would put in your RFP the provisions that will govern the services that the ultimate contractor is going to be providing to you. So if indemnification is important, which we absolutely think it is, and we'll touch on that later, that should be included in the RFP. If there's certain liability provisions you want to include, put that in there. If they're going to be providing you with a product that you want to ultimately own the intellectual property in, that should go into the RFP as well. And you should require the candidates to sign when they submit their response. Have them sign the RFP indicating that by submitting their response, they're agreeing to those terms. So then once you get into the actual contract negotiation, you're already almost all of the way there, and they've already assented to your terms. And there might be some give and take, but for the most part, you've gotten your terms in there at the point where you have all the leverage and not where you're down to one or two candidates and they can really push back on those terms. So we're going to move into the key contract provisions. So when you are in the negotiation process and when you are drafting this agreement, which, as we said, you should start with your own model so you can put all of these provisions in there, these are the provisions you really want to pay close attention to and make sure are included in the contract. So this is just a brief overview. You'll have provisions regarding payment and ownership. So what is your budget? How are the payment terms going to work? What's the schedule of payments? What's the scope of the agreement? What is each party doing? What are their responsibilities? Ownership, the intellectual property. Are there licenses being given? Will you end up owning the final product? That should all be addressed. We'll talk about risk allocation, any damages, and what any sort of limits on damages, indemnification, which any sort of shifting of risk or liability, and insurance obligations. And then we'll get to when contracts go south and managing disputes and term and termination. So we're going to start with the scope. And this is very important and I think sometimes neglected. So many times we'll get an independent contractor agreement and it will say, you know, XYZ Association hereby engages contractor to provide certain consulting services in connection with XYZ program. And that's it. And that's great, and it's wonderful if the parties have an understanding in their heads of what that person is going to provide to you. But you really need to put those thoughts up here down on paper so that the obligations are clear. And this becomes important if in the event the contractor is not performing to the obligations, you know, and up to the levels that you expected them to perform. You want to be able to say, well, in our agreement we said that you would provide this product by this date. You have not provided this product by this date, so therefore you've breached your obligations. It's very hard if a contractor is not performing up to the standards you want them to. If you just have a very brief description of the services, they're providing consulting services, it's hard to then say you're not performing pursuant to the contract because they'll say, well, we've been consulting and that's all I'm obligated to do. So it really helps to get a very clear picture of what they should be doing. And this is especially important in any sort of contract where they're doing research and writing, where it might be an ongoing project and then at the end there's a deliverable. There should be certain benchmarks and guidelines within the contract as to what they should be doing throughout the term of the contract.
And Audra, one of the points you probably are getting to, but you know, a trick that often works is to incorporate the proposal that came from your contractor as a part of the agreement, perhaps as an attachment, to again, you know, talk about leverage. That's the point in time where you're going to get the best promises from the would-be contractors when they're not sure if you're going to hire them or not. And so, it's not always the perfect fit, and sometimes the way the proposals are worded, it's difficult to incorporate as an attachment, but oftentimes that helps, and it's a nice shortcut to putting yourself in a better legal position.
Yes, thanks, George. That's a great point. And the final thing that you should make sure when you're defining the scope and each other's obligations, lots of times contractors will try to throw in some sort of disclaimer of warranties. We're going to provide this service, but we're not making any warranties as to its appropriateness or fitness for a purpose. That really helps to limit their liability, which we don't want. They're providing a product to us, and it should be the best that they can provide. So rather than permit, and this can be addressed in the RFP, this type of provision will not be allowed in our final contract. And it's always good to have some blanket language in there saying, they'll comply with all applicable laws and perform in a professional manner, some sort of catch-all for their performance under the agreement.
Going back, I think we missed a slide.
Oh, we did?
Slide 10.
Oh, yes, apologies. Okay. So this is getting back to some basic contract 101 terms. And, like we said at the beginning, a lot of this is very basic, but these are all some very important points that you should remember whenever you are looking at a contract and negotiating a contract. And as George mentioned before, there's the big lie, the big myth. It's a standard provision. We can't change it. That almost never is the case, and generally that's a provision that is something you definitely don't want to agree to. There's something in there that you are going to want to modify. It's always a good idea to push back, modify it to suit your organization and to be more favorable to you. And then you can negotiate from there.
And even if it's in very small font size and it's in a PDF file, it's all negotiable.
We can modify PDFs to Word documents and redline them till the end of the day, so absolutely. The second point is to read everything in the document. Once you get past the meaty business terms, the obligations that we were just going through, sometimes you then look at all the legal terms and the boilerplate and think, that's probably fine. We've got what they're doing. We're good. We've got the payment terms in there. But you really want to know what everything says. Almost every agreement will have some boilerplate provisions at the end that will address, let's say, assignment. And you might not look at that too carefully, and then 6 months down the road, your contractor might want to assign the agreement to a subsidiary that you've never heard of and don't have any experience with. You need to know if your agreement allows them to do that, and you should know at the outset whether it will allow them to do that. So you really do want to make sure that you've read everything, you understand what it's obligating you to, and that you're okay with that and that suits your organization. And as George was mentioned before, it's a really good idea to start with your form agreement. That does put you in a great position, and it helps you have an agreement that's suitable to your organization, to your needs. Lots of times, organizations will, give you a big form contract that they use for every organization, for-profit, non-profit, it doesn't matter. So it's really good to start with an agreement that your organization is comfortable with. Be ready to walk away. There's almost no deal that you can't find another service provider or contractor to work with you for. So if someone is offering you just horrible terms, they won't budge on negotiations, you do need to be ready to walk away. And finally, if you ask for something after you sign the contract, it's called begging. So make sure you have everything in there before you sign it. Before you sign it, read it through one more time, make sure everything you can need is in there, and then you can feel comfortable signing it. So now we're going to skip ahead. So the next provision is payment terms. And again, we've certainly seen a lot of contracts with some ambiguity about the payment terms. They might say, in exchange for the services the contractor is providing, we will pay them $10,000. But it doesn't say when. It doesn't say if there's any deliverables tied to that payment. So this is what you really want to think about when you're constructing the payment provisions. So there's two methods of payment schedules that or types of payment terms that we've seen. So it's a fixed price, which would be we'll pay contractor $200 per month for their services, or you can do a time and materials type of payment term where it's $100 per hour and reimbursement for expenses and materials that they expend on their services to your organization. You want to make sure that your payment terms very carefully define any payment obligations upon termination. So that can mean both your obligations towards the party that you're contracting with as well as their obligations back to you. So for instance, if it's a party that you've contracted to do services and it's terminated midterm because they're just not performing well, you might include a provision saying that anything that they've done up through the notice of termination, they'll be paid for. On the flip side, if you've entered into a royalty agreement or something of that sort where an organization is remitting royalties or payments to you, you'll want to specify when those payments will continue through and when they will cease. One thing that we always like to recommend, and this really goes to the concept that whoever holds the money really holds the power, so you always want to withhold final payment until all items are provided to you, all services are completed. It's okay to pay throughout, certain amounts throughout, but you always want to withhold some amount of the payments just to make sure that they have some incentive to perform. If they're holding all of the money, their incentive might rapidly decrease to provide a good service or products.
And similarly, if you paid them largely up front and then you're having service performance issues, which frequently happens, your leverage is very low at that point to be able to force corrective changes. Whereas if you're paying, as Audra said, kind of on benchmarks throughout, it's a lot easier to keep control of that process.
You might want to include a provision in the agreement that talks about when it's appropriate to renegotiate prices and payments. If it's a long-term relationship, there might come a time where what you've been paying is no longer appropriate, whether it's too much, if their level of services have decreased. You want to put in there some wiggle room to be able to renegotiate the payment terms, and you might write in some sort of renegotiation triggers. If it's a 5-year contract, you might want to have an annual review of the payment terms, and so at that point you can review and see what's appropriate and move forward from there. You do want to be aware of any provision that has third parties receiving funds that are actually owed to you. And one instance of this is if you've hired a company to obtain ad sales for your journal or publication, and they are collecting these sales. So what you want to avoid is having those payments coming to that company that's working for you, because that is ultimately their money, but they might have it written in there that the ad sales revenues will come to them, they'll retain their cut, and then they'll give you the rest. It's just not ever a good idea. The money should come to you, and then you can pay them their cut. Again, whoever has the money has the power, and it's easier for you to keep a good accounting of all of those funds.
And I know a few real-world examples that have happened not too long ago with some of our clients and some folks who have talked to us. And when the problem happens is when this company that's collecting money for the ad sales or booth sales or registration sales, it stops paying you, it's because they don't have money to pay their own bills. And so when it comes time to collect or sue or whatever it is you want to do, it's going to be very difficult to get any money out of it to begin with. So it sounds like a common sense thing, but there are a lot of contracts that are out there that I've seen where that is the setup.
Thanks, George. So just a couple of additional thoughts when you are thinking about your budget and payments for your agreement. You want to be really careful about any agreements that deal with commissions or exclusivity. And one instance that we see this a lot in is housing contracts. So you have a company that provides all of the room registration and related services for your meetings. What we would absolutely recommend, because associations often do contract out with hotels for several years in advance, you want to have your underlying agreement with the housing company, and that will provide for your own terms of termination and obligations upon termination with that housing company. But oftentimes we'll see in the hotel or convention center or hotel agreements where the housing company will actually be named by name in the hotel agreement. And this creates a sticky situation. If you have an agreement for a hotel in 2018 and you've named your current housing company, but then you terminate your agreement with your housing company as of 2013, but they're still named in all of your agreements for years out, and that can create a sticky situation with the hotel and with the obligations you owe to the housing company. So what's a better practice is to identify in the agreement with the hotel, the organization may identify a housing company, and they should just be defined throughout the agreement as the housing company. And then if they're entitled to commissions by the hotel agreement terms, it will just be the housing company that you've identified, so you haven't named your current housing company in all of your hotel agreements for years out.
We've had to help, unfortunately, too many clients out of situations where they're very unhappy with the housing company that they've contracted with, and then they go and terminate the agreement, but they find out that contract had a tail provision that basically ensures that housing company is going to get commissions on all rooms booked for those hotels, regardless of who the housing company is at the time. So it's really important to be careful in that regard. Of course, there are many contracts where you're going to be making payments after the contract terminates because, say, commissions that you're paying for ad sales or fundraisers or other people like that, a lot of times they're going to get paid after the fact based on what they generated over the course of a year or something. If you terminate the agreement, there may be a tail that says you still have to pay out for the balance of those commissions post-termination. That's fine and perfectly appropriate, but just be very clear in your contracts when those obligations end and when they don't.
Thanks, Jeff. And similarly, the same concepts are true with anyone who's securing ad sales for you in your publications. You want to make very clear in your contract with those organizations, any obligations upon termination, when they must stop selling ads, when they can stop collecting commissions on those advertisements that they sell. The clearer you can make it in your contract, the less heartache and possibly legal offenses you'll spare yourself going forward. One other thing to consider, which is the most appropriate in meeting agreements, is to require mitigation of damages. So if for some reason your organization can't perform, the other party needs to make some reasonable efforts to minimize the damages that you're going to owe for your lack of performances. And that is actually something that George is going to discuss in more detail right now.
So this is a mini 4-slide deep dive into meeting contracts issues. I apologize for those who don't have many of those, but I promise to be brief on it and can take some questions after for those who do. So many of us in the audience work for organizations that put on meetings, conventions, trade shows, and other activities where we go to a hotel and say we would like to use your rooms and meeting space and food and beverage, and our individual attendees will make reservations in the rooms. You set aside a block, and we fill that block or attempt to, and in exchange you make those rooms available. The key issue, for those of you who are in this world know it very well, the key issue is, are we meeting that room block, or are we providing enough people, reserving enough rooms so that the hotel doesn't go after us for attrition penalties or other forms of liquidated damages? Another big issue is, what if, heaven forbid, we have to cancel for some reason? Are we on the hook for significant liquidated damages? And this is a very broad overview and too short a treatment of the big issues with meeting contracts. But they're the ones that cause the most heartache and the ones that are subject to the most negotiation. And what we always recommend in these types of agreements, and just as Audra said, is some kind of mitigation clause. We understand that the hotel, our position and the position of most of our clients is, we understand that you hotel need some form of assurance that these rooms that are set aside will be sold or rented by your members. But there's also other ways to fill that room, and there's also other ways for the hotel to achieve revenue that may not be through our members. And we shouldn't be penalized if ultimately those rooms are filled and the revenue came to the hotel, or at least we shouldn't be penalized to the extent that the liquidated damages provisions in the hotel contracts would have us be penalized. So a mitigation clause is a huge, important provision to include as part of that. The way it normally works is the hotel says, here's your room block. If you go below 90%, 85%, wherever it is these days of your block, and less than that gets utilized, for each room under that percentage level, we're going to charge you, organization, for those rooms. So you're buying those rooms anyway. And what we would normally advocate in that situation is, that may be the case, but first you have an obligation to sell those rooms and not just leave them vacant or otherwise charge us for them even if they are sold. So even though you may call it a liquidated damages provision, we still want you to mitigate, and we're going to require you to do so in the contract. And then we will decrease the amount that we owe you based on your mitigation. And we need some proof, some documentation. So that's number 2 here, the timing of the payment issues.
George, just want to interrupt for 1 second. Let's make sure everyone understands what liquidated damages are. Damages is a legal term for essentially the amount of money that you have to pay if the contract is breached by one side or the other. The 2 primary forms of damages are actual damages or liquidated damages. At least these are the 2 primary forms that nonprofits will see in their contracts. Actual damages means the actual amount that the party lost as a result of the breach of the contract. The amount amount that they can prove that they lost essentially in profits as a result. Whereas liquidated damages are simply a set amount that the parties agree to in advance when they're contracting. If they put into the agreement that says, for instance, if the nonprofit cancels the agreement, anytime within a year of the event, then it shall owe to the hotel, $500,000 in liquidated damages, irrespective of what the hotel actually lost. So what George was talking about is wanting to avoid a situation where you have to pay that $500,000 in liquidated damages, even though the hotel was able to go out and resell many or if not all of those rooms and still earn the profit that it would have earned under your contract.
Right. So what we are doing is pushing liquidated damages closer to actual damages. And that's another key point of that is when the payment is due. The normal form hotel contract will say if you owe us liquidated damages, you owe us at the time we say we assess it. For cancellation, it's at the time you cancel. For attrition, it's the last day of the meeting. But rather, what we advocate strongly pushing back on is saying, no, the timing of our payment obligation is after we get proof of your mitigation efforts and after we see and we agree on what the ultimate amount owed is. Another key point, again, on the liquidated damages front, that hotels, the form hotel contracts will either not address or address in a way that's not favorable to the organization, is to, in a way, tack on additional charges to the liquidated damages. You'll see with your food and beverage agreement, for instance, there's a service charge that comes with your food and beverage payment. There is also often a resort fee or other form of kind of additional charge that goes with the room rate. The room rate's never the actual room rate these days. You're now paying for your USA Today even. So anyway, we have to make clear in our liquidated damages provision that those sorts of things don't apply to those rooms that we're talking about. I would also try to remove, obviously, local and state sales tax, but that's not up to the hotel. That's ultimately up to the taxing authorities as to whether they're owed or not. Another provision that we often advocate including in order to limit the damages that an organization may owe if there's an attrition issue, a failure to meet the room block obligation, or a cancellation issue is to apply a multiplier to the room rate. So as you get an obligation to pay only a portion of the room rate. Again, pushing liquidated damages closer to actual damages. When you fail to occupy a room, the hotel is not out the $150 room rate. The hotel is out its profit because they're cleaning one less room. They're doing one less thing for that room. There's a certain amount of variable cost that goes into that. And so what many meeting planners have struck on, and we certainly advocate this sort of approach too, is to apply a multiplier to the actual guest room rate when it comes to attrition so that we're not paying full freight for each of those rooms, but rather a percentage, 75 to 85%, for example. Same thing for food and beverage. What we found is obviously the profit margin is different for food and beverage, and you can command a much lower attrition fee for food and beverage if they're not buying food, they're not paying the staff to serve the food. So there's more of an ability to push that down. One other point on food and beverage that's important from an attrition perspective. A lot of organizations find it beneficial to just say, here's our minimum. I mean, here's what we have to pay you in food and beverage. So it's not tied to the number of people they're serving. It's not tied to the size of the room. It's not tied to how many events. It's tied to the actual dollar amount they're spending in food and beverage. And we're willing to take that. We're willing to say this is what we're paying no matter what. So if attendance is down, those people eat well and they drink well. So we're not in a situation where we're just paying a check over to the hotel or to the conference center for attrition and not getting any other benefit out of it. So it's another point to consider. Again, in a way, it's something that those who are seasoned in the industry have probably found out years ago, but nonetheless worth repeating. Finally, an important issue that needs to be addressed in contracts, if at all possible, is when do we count those rooms as having been resold? If we have a large hotel that we're getting a room block for half the size of the hotel, if we agree that there is a obligation for the hotel to mitigate, the hotel will say, well, we only mitigate after you reach your 80% or 85% level. Then we count the last room sold towards yours. We don't count the room sold in the interim. It's unfair, and it's difficult to address in the abstract. One way that we've often suggested doing it is apply an average room rate to the property, so that it isn't a situation where the hotel has to actually sell out, not average room rate, average occupancy rate. It isn't a situation where the hotel has to actually sell out for us to mitigate our damages that are owed, for the hotel to mitigate the damages that we owe the hotel. But rather say, over this time of year, over the last 3 years, this hotel has been 75% full each year. To the extent that the hotel remains 75% full, regardless of how many rooms that we utilize, we don't owe attrition. We don't owe a payment. Now, these are all negotiating terms. The hotel will say, well, we were 75% full, but we got a better, deal this year. These are all numbers that you can argue with, but it's a concept that should be put down on paper, so you're not stuck with looking for an almost completely full hotel before you can get the benefit of mitigation. This would require an obligation to review the ledgers from the hotel, review some records from the hotel to make sure that they are, being accurate in terms of what their past occupancy rates have been, as well as what the utilization is for that particular time frame over the meeting. I have had hotels suggest that there's some big privacy issue with sharing that information. I can assure you that there are any number of ways to remove the name, just use initials, whatever it is that they may want to do. As long as we can see the records, we're happy to entertain their privacy concerns.
George, before you leave meeting contracts, one question for you. Certainly, you mentioned earlier when you're talking about things like contracts with your independent contractors, your consultants you're hiring, your photographers, your videographers, it's very common and acceptable and appropriate to start with your own standard contract form as a starting point for those negotiations. But as we have seen many times over the years with hotels and convention centers, it's generally very difficult to be able to start with your own contract form. It's almost impossible in most situations, unless you're holding very large meetings and you have incredible leverage. But what we have done over the years, as you know, I think you developed it first, is kind of have a standard addendum that is tailored for your organization that you utilize either to try to get it or certain provisions of it kind of attached to the contract, or at least to use those terms as kind of negotiation points to try to get the language changed to reflect what's in the addendum. Do you want to speak to that for a second?
Yeah, it's a great approach, and it's a bit form over substance, but it works because dealing with the other side, you do get that pushback that we'll have to go to legal, or we have to start with ours. That's the rules here, and those sorts of things. So you're overcoming an initial obstacle that often comes into play just from the structure of the way the hotel companies operate and what their permissions are. So it's been a great boon, and one, the best provision in the addendum is the last one, which says, in the event of a conflict between this addendum and the contract, this addendum controls, and that's important. It's not of much value if the contract language controls, and I found that again, a lot depends on markets, a lot depends on the size of the meeting you're bringing, but that tends to be far more welcome than here's our form meeting agreement. My experience has been like yours, that only the very largest organizations that have the very largest meetings can kind of push that one through with their own form agreement. But the addendum has worked, and it's a good approach to try for those who are doing significant amount of, or a regular amount of meetings even. I got to move here. All right, so back into the general contract world. We've left meetings and back into the general world. What are some key provisions on the intellectual property front? Each organization here has valuable intellectual property in its name, its logo, its membership mailing list, and very often the contractors you're working with may seek to, in one way or another, exploit that value for their own benefit. We may be willing to do that in exchange for a fee. That's what a royalty contract is all about. They get to use our name and logo or some other mailing list or intangible property. In exchange, we get maybe a cut of the revenue of their program that they're doing, and we're fine with that. But we do want to protect the way they use it. We want to make sure we have the rights to see how our organization's name and logo is going to be used in print and advertisements, and have the right to say no. Similarly, the organization may have trade secrets or confidential information that need to be protected through a confidentiality clause. a lot of times this happens in a joint venture agreement or some other form of close relationship you're going to get with the other side to put on a joint event, to publish a paper jointly, et cetera, where clear protection of our rights and what it is that we have is very important. One point on intellectual property that some of you may have heard before, but that bears repeating again and again, is if you're contracting with an independent contractor to produce some type of copyrighted material, some type of material that's subject to copyright, like a photograph, an article, some written product, a video, the presumption under the law for copyright is that that individual, the creator of that product, owns all rights in that, unless there's some form of transfer or license transfer or assignment of the ownership. All we would be presumed to have if we didn't have a good contract provision, all the organization would be presumed to have if they hired, for instance, a photographer to take pictures at an event, is a license to use those photographs in the way contemplated by the parties. That means permission to use it, not ownership. Now that may be fine for some of the purposes, and maybe the other side saying, well, I'll charge you X for copyright transfer and I'll charge you Y, which is lower for license, and we're willing to do that. But we need to be approaching this with open eyes. A lot of times organizations will pay freelancers to do articles and those sorts of things, and will certainly want the right to distribute that product, that article, that white paper broadly, sell it, do all sorts of things to exploit its value. And can and should demand ownership, and that needs to be in writing in the contract that you've negotiated. A good fallback is a very broad license that allows you to use it in any way possible. The difference is a license or a permission to use it allows that creator to continue to own it and continue to use it how he or she would want to use it as well. So if you have an article or a white paper that you don't want to see out there elsewhere, perhaps an exclusive license or a copyright transfer would be in order. The final point here before I turn it back over to Audrey is, what if a contractor provides something that is owned by a third party? Very frequently, particularly in the white paper consultant world, there may be materials that are subcontracted out or portions of a white paper that may be written by some third party. We want to include in our contract with that contractor, you warrant that anything you provide to us, you either own or you have full rights to allow us to use it in whatever way we're going to use it. And that should be made clear in the contract.
And of course also a representation and warranty that the material being provided doesn't infringe anyone else's copyrights, is not defamatory, doesn't invade anyone's privacy, kind of all the other reps and warranties that you want to go along with it. Those kind of things are very important to avoiding things like contributory copyright infringement, where, say, the nonprofit as the publisher could be held liable even though it wasn't directly responsible for the infringement, but it facilitated it by kind of republishing someone else's infringement. Yeah, question in the back?
Precisely. In a technical journal context, there are two important points that probably go in addition to what I just said. One is that the peer reviewers, the members of the committee who actually are part of that, should also give some form of assignment or license to the organization, so that to the extent that they're contributing to the work and actually adding some copyrighted material or subject to copyright material to the work, that they assign or license to the organization any rights that they've created in that situation. Also, I guess it's reiterating what I did say before. A lot of times in those situations, those works will include references to excerpts from, third-party works, graphs, other sorts of visuals that may be a part of it. And what I've seen in the form contracts we've looked at for journal publishers is that kind of warranty that says, to the extent that there's any third-party materials, you warrant that you have the right to, that they have given us the right to publish it as we plan to. It's important that in that context, you may want to have the right to see the license or the written transfer agreement that comes from that third party to the person who's submitting it, and you can demand that in the contract as well. The problem that is a practical perspective that comes up in this situation is a lot of times these people submitting this aren't getting paid for it. And the more burdensome the contract is, the more kind of one-sided the contract is, the more likely you are to get pushback from these academics or whoever's submitting it. And it's a management issue, and sometimes you may have to go with a license instead of a transfer, or you may have to go with a broad license back to the author to say you can use this in these ways if you want to use it, to encourage them to submit. A lot of times, particularly if there's a professor that's submitting it and those sorts of things, they'll demand that at the outset because the terms of their relationship with their university, for instance, may require it. So there is kind of a case-by-case aspect to that I think you need to take into consideration. And while sometimes the best deal for the organization may be you transfer everything, you show us all the permissions that you have, and the best kind of legal bargain for the organization may result in fewer submitters, fewer participants, and that happens with associations, time and again. You want to make sure that the authors giving it to you for free or just for recognition are not going to be scared away by onerous terms.
And it kind of goes without saying, but George's point should make you realize that it's by far become a best practice in the nonprofit world. Every non-employee who's contributing any copyrightable content to your organization, authors, article writers, speakers, giving PowerPoint presentations, everything like that. There should be something in writing that you require all of those folks to sign that either transfers copyright ownership to your organization or gives you a sufficiently broad enough license to use that work for that intended purpose and in any other way that you may want to in the future. Irrespective of whether they're being paid or not for the work, it's critical to get in a best practice of always getting some sort of assigned copyright assignment or license. And even with committee members, certification committee, for instance, that's creating standards for a new certification program, anyone who's creating copyrightable content should assign the copyright interests over to your organization.
Okay, Audrey.
Okay, so the next contract provision we're going to talk about is in the general risk allocation area. And the first thing we're going to discuss is damages. And as Jeff referenced earlier, damages are essentially a money substitute in the event of non-performance or breach that is designed to put the non-breaching party in the same position it would have been in if the party that did breach had performed. We're seeing a lot of proposals and contracts to cap the damages to the actual value of the contract. So if the value of the contract is you're paying $10,000 to someone to provide a service for you, the most you can recover in damages is $10,000. This is generally more advantageous to the other side and not the nonprofit organization that's contracting, just because there's a strong possibility that your damages might actually be higher than the value of the contract if they don't perform. So that's something that we would really encourage you to evaluate the potential maximum harm that could come to you and any sort of costs that would be incurred to repair the breach or the non-performance of the other party before you agree to cap the damages to the value of the contract. We've also seen a lot of suggestions to limit damages to actual damages, so the actual costs that you incur because of the other party's non-performance or breach. And that's a little bit more reasonable, but you do want to think about exclusions to that. So, for instance, if the other party was engaged in willful misconduct or just was extremely negligent, something that caused harm to you to a level that is beyond just the actual damages, and those can happen, so you might want to exclude those from any sort of cap on damages. So indemnification, and this is essentially compensation. So if any claims are raised against you resulting from another party's actions or negligence, indemnification essentially requires them to reimburse you for any costs that are incurred in any sort of claim that arises because of their actions. And in crafting, we'll talk a little bit more in depth about crafting your indemnification provisions, but they can apply to negligence, intellectual property infringement, breach of confidentiality. There's lots of different instances in which indemnification can and should apply. So these are some things that you want to avoid when you're drafting your indemnification provision. The first one is any sort of promise by the other side to indemnify you for their sole negligence. What this essentially means is that they will indemnify you for any claims that arise out of their negligence alone. So if you contributed to this claim in any manner, that indemnification obligation goes away. So you want to make sure that there's no indemnification that's limited to their sole negligence. The same goes for gross negligence. Gross negligence is something that is very extreme. It's, highly, it's just bad. So, it's, words are failing me, but it takes a lot to sustain a claim of gross negligence, so you don't want to have that word in there either. And the same goes for as determined by a court, because, this will then throw the process into a court, and they might end up limiting the provider's responsibility more so than it would be if you had an indemnification provision that was indemnifying you for their acts or omissions. Other language you want to avoid having in a provision is any indemnification obligation that requires you to provide indemnification coverage for third parties' actions. So lots of times this will occur, again, in the context of a meeting agreement where the hotel wants you to indemnify them for any actions or negligence that your meeting attendees have, enacted that led to a claim for the hotel. You want to avoid as much as possible incurring an indemnification obligation for a party over which you don't have control. So essentially you should only be indemnifying for your organization and your employees and agents. You want to avoid any sort of agreement that doesn't provide indemnification by the provider of services. You always want to make sure that they are indemnifying your organization. And lots of times, again, going back into the meeting agreement context, you'll see language where they want your organization to indemnify them for any occurrence related to a meeting. So that means essentially anything that happens while your organization is there that's in any way stemming out of your meeting, you're obligated to indemnify the hotel for. And that is just extremely broad. And it could also end up requiring you to indemnify the hotel for negligence by the hotel's agents. So you want to avoid any sort of language that's overly broad. Some things to consider when you are crafting an indemnification provision is whether or not it makes sense to have reciprocal mutual indemnification. As we said, you always want your service provider to be indemnifying your organization, but it often makes sense to have your organization also provide indemnification back. And lots of times this is actually a very good negotiation tool where you can start with a one-sided indemnification on their part, and then if they're pushing back, you can agree to a mutual indemnification. You want the indemnification provision ideally to only have each organization indemnifying the other for actions that are within their control. So as I said before, your employees, your agents, your subcontractors, but there should not be any sort of indemnification for third parties. You can consider whether the indemnification should provide defense costs. So if they'll provide attorney's fees, or any court costs or filing fees that were incurred with any sort of defense of a claim. So if that is the case, that should be written into the indemnification provision. And we have seen some provisions that limit the scope of indemnification to insurance coverage. So you'll indemnify to the extent that your insurance will cover you. And this is permissible, but this will touch on something that we'll discuss a little bit later, is that if you're going to agree to that provision, you need to be really sure that the other side has insurance, and that they have insurance coverage, and they haven't somehow just had you agree to indemnification to their insurance coverage when they don't have any coverage. So these are some special considerations with indemnification. So lots of times you'll see the indemnification provision will say, this party hereby agrees to indemnify, defend, and hold harmless. So the duty to defend is actually separate and distinct from the duty to indemnify. Indemnification is essentially reimbursement of costs that you incur for a claim. And so indemnification really only kicks in if the decision on the claim is adverse to the indemnified party. But the duty to defend actually kicks in when the claim is made. So this means that the party that is indemnifying the other party will handle all the defense of that claim. So if that is something that is going to be written into the contract, you also want to consider what rights and what obligations each party will have. So the party that is the indemnified party, will they have a right to choose the counsel? Oftentimes the party that is handling the defense wants to have their own counsel, but you might give the indemnified party a right of refusal. Will the indemnified party have the right to agree to a settlement? If a settlement is offered, will they have the right to agree or refuse that? Another thing you want to think about is how long the indemnity obligation will last. Lots of times, once a contract terminates, you assume all the provisions within it expire with the expiration of the contract. But lots of times there are services that are provided or that are ongoing, and there might still be some claims that arise after the termination of the contract. So you need to consider the nature of what's being provided and how long it might take for a warranty, the accuracy of a warranty to be determined to not be that accurate and how long a claim might arise. So you need to think about whether or not it's appropriate for the indemnification provision to extend past the termination of the agreement. Several of your organizations might occasionally contract with government agencies, and oftentimes convention centers are actually branches of the government. And lots of times they will come to you and say, there's limitations on what we are allowed to contract to, what we're allowed to agree to, and oftentimes that will include a prohibition or at least a limitation on that government agency's ability to indemnify your organization. So a way to kind of get the most coverage you possibly can and address those possible limitations is to say that that agency or organization will indemnify your organization to the maximum extent allowed by applicable law. So there you're getting the maximum amount of indemnification, which might be limited, but you're at least getting as much as you can. And the final consideration is intellectual property infringement. So when you're writing an indemnification provision to cover intellectual property infringement, you want to think about who is being indemnified. So let's say, for example, your organization enters into a software license agreement, and there's this software that is being licensed to your organization in which, by virtue of the contract, you can license to all of your members. In that instance, you might want to have the indemnification provision cover all of the licensees as well, so that if there is a claim of infringement, your members who have been using this licensed software are covered. You should also be clear in that sort of indemnification provision what intellectual property is being covered. Is it just the current intellectual property? Is it future versions of it, modifications of that intellectual property? That should all be addressed in the provision. So in terms of limiting your risk and limiting your exposure to liability, there's a few things that you can do to limit third-party reliance on your association. So the first thing to think about is endorsements. I know royalty agreements are a really good source of non-dues revenue for lots of your organizations. And in these agreements, your organization is essentially licensing its name and mailing list and other intellectual property to a third party so that they can promote their products and services to your members using your intellectual property. What you want to do to manage any sort of reliance by those individuals who are receiving these promotions with your association or organization's name on them is you want to make sure that you're limiting their reliance or their thoughts that your organization in some manner is endorsing this product or warranting that it's going to be the best product, so that they can't later come to you and say, we relied on your endorsement and this product didn't work for us and therefore we're bringing a claim against you. And there are several ways that you can manage that exposure to liability. And the first method is in the contract with the other organization that you're licensing your intellectual property to. So you want to be clear in there that your organization is not liable for any claims or any sort of things that go wrong with the products that this third party is providing to your members. You want to make sure that all of that liability shifts to the party that's actually providing those products to your membership. And this is also where a good, well-written indemnification provision would come in handy. But you also might include in that agreement, and this can get varying levels of pushback, you can require or try to require that party that is using your intellectual property to include a disclaimer on all promotions to your members stating that your organization does not endorse or guarantee this product or service. Obviously that's not something that providers always like to include since they're promoting their product and then saying, well, they don't really say it's that great. But, it's worth trying, and sometimes it works, and it really does limit your liability. You can also make clear in any materials, on your website, wherever these promotions are appearing, that, you can put that disclaimer there and make it conspicuous and make it clear that your association is not in any way endorsing these products.
And of course, none of this is a substitute for due diligence, because a lot of times you are endorsing. You may not be guaranteeing the product or service and guaranteeing it's going to work as advertised, but you are endorsing the provider as kind of a preferred provider that you're encouraging your members or constituents to utilize. So really the best way to minimize your liability, kind of exclusive of anything that's in the contract, is to do your due diligence on the company and the product or service before you enter into the deal. If you do your due diligence, then it's going to be very difficult for someone to make a claim that your organization was negligent in issuing that endorsement.
And I know we're getting close on time, so this is where my ability to talk very quickly is going to come in handy. So some other ways to manage your liability is to make the liability flow down to third parties. So if you're subcontracting any sort of service out, so something that your organization should be handling, you're having a subcontractor come in and provide those services, make sure that they are indemnifying you for anything that they're providing, and vice versa. If a service provider for you is subcontracting out, make sure that they do have those indemnification obligations in their agreements with the subcontractor as well. Waivers is a good idea if you're having a program or an event where there's some risk of liability or claims. If you're doing a fund run to raise money, have all of the participants sign a waiver releasing the organization from liability. They're participating voluntarily, they know the risks, they assume the risks, your organization is not liable. And finally, have insurance coverage. So insurance coverage should be a provision that's included in your contracts, but this is some basic ideas about your insurance coverage. So you should always maintain your coverage, and it should correspond to your indemnification obligations and your liability exposure. So have a good sense of what exposure your organization has and what its obligations are in terms of indemnification, and then make sure, communicate with your insurance provider so they're aware of that, and make sure that your policies are able to cover that scope. You might want to consider, if you're an organization where your meeting and event revenue is a significant portion of your revenue, you might want to consider also purchasing event cancellation insurance. And what this does is it can cover any losses from a cancellation of a trade show or event. It should be noted that this usually applies in the instance that a force majeure event happens. There's a hurricane, there's a terrorist attack, transportation shuts down. What it does not cover for is any sort of financial loss. So you just didn't perform as well this year, you didn't have as many exhibitors or attendees. It won't cover that, but it will cover any outside occurrences that cause the cancellation of the event. You should continuously reassess your liability exposure and your indemnification obligations, so to make sure that your insurance coverage continues to cover all of your activities. And monitor any legal developments. So if there's any big decision that exposes associations or charities to larger areas of liability or risk, be aware of that and make sure that your insurance coverage expands to meet any of those developments. Who should be insured? Make sure that your legal name is in the insurance policy, but also if you're operating under any sort of trade name, if you operate under your acronym, make sure that the insurance policy addresses all of those names. Decide if your insurance coverage is going to extend to your subsidiaries or your parent or affiliated organizations. You'll probably have a separate directors and officers insurance policy, but just consider who needs to be covered. Again, as I mentioned before, you want to make sure that any service provider to your organization has insurance coverage to cover their obligations to you. So that should be a requirement in the contract. You can write in the contract that the service provider is obligated to provide you a copy of their insurance contract so that you know that they have that. You can require them to name your organization as an additional insured, and they should also be required to provide you notice if for any reason they cancel their insurance policies. The one important nuance is waiver of subrogation, which I think is a term that we might just skip over because it's not a pretty one. But basically, subrogation allows a third party to essentially step in your shoes and bring a claim against a third party for damages that are caused to you. So this, the most frequent example of when this happens is if you're in a car accident and your insurance company can step in and try to get damages from the other party to the car accident and get those claims for you. Lots of times in service contracts, we'll waive that. And what that does is it means that that third party is not able to step in your shoes and get those damages. And the effect of that is that it really does limit the amount of lawsuits and the amount of damages. And it basically has the parties deciding that the insurers will cover the risks and that the costs of those, the insurance will be allocated amongst the parties. So that is one clause you can choose to put in.
Two really quick points on insurance, and we're in the home stretch here. We're going to go a few minutes over, but not much. On insurance, two things. First off, since we're talking about contracts, generally speaking, with the exception of employment contracts, there is no general insurance coverage available for breach of contract. So if your contracts are breached, that's generally not an insurable event. with some limited exceptions for special types of policies. And the other point is, all insurance policies are not equal. All different types of insurance are very different. When we're talking about, for instance, making sure the other party to a contract has particular insurance coverage, you need to make sure it's the right type of insurance coverage that will cover claims that are contemplated by that agreement. We have yet to do an insurance coverage review for a nonprofit organization where we haven't found significant gaps in coverage. People a lot of times think they're covered for certain things and they're not. It's a really important area that we unfortunately find a lot of deficiencies in the nonprofit world.
Thanks, Jeff. The final provision that I'll be talking about is dispute resolution. So, we all want to think that the agreements are going to be conducted successfully and we won't have any disputes, but we need to provide for those disputes in the event they arise. So if your contract provides for litigation in the event of a dispute, you want to make sure that you include the venue where that litigation will be taking place and the law that it will be governed by. You also want to include a statement as to whether the prevailing party will be able to recover attorney's fees and costs. We do see some provisions for mediation, but generally the parties somewhat mediate disputes while they're trying to negotiate through the disputes, and so if it's gotten to a point where you need a third party to intervene, mediation is probably not the right solution. So we do recommend an arbitration provision as well, and that's where you'll have a third party neutral arbitrator make a binding decision that can be enforced in a court. So similar to litigation, you'll want to make sure that you include a statement as to where that arbitration will take place and what law it will be governed by. You can put into the contract how the arbitrators will be chosen, and again, whether the parties will share the cost of expenses or whether the prevailing party will be entitled to expenses.
All right, thanks, Otter. George is going to wrap up. Just one point on arbitration. While as a general rule, probably more often than not, we recommend including mandatory arbitration clauses in contracts, there are some situations where strategically it makes more sense to not include an arbitration clause and to force the parties to go to court if there's a dispute. So just don't automatically rush to that decision.
Thanks. Okay, just the last contract provision that really needs to be talked about is term and termination. And as you see each of these bullet points, the primary issue that we've experienced time and again with nonprofit organization contracts is a situation where the organization is locked into a bad deal and they want to get out, and they look at the contract that they signed and realize they can't, or it would be very difficult to get out. They would have to show some form of breach of contract or that sort of thing. Time and again, it is far more frequent for us to get approached with that problem than to get approached with the problem of the other side, the service provider, the product provider, getting out early and us wanting to keep them in. It's just the nature of the beast. We in the nonprofit community, are usually in the position of being buyers of products and services. And when we're talking about contracts, as I said at the outset, we're talking mostly about nonprofit organizations purchasing products and services. The people who are selling the products and services like an annuity. They like the idea of a very long-term deal where money is continuing to come in and they can count on that. So what we almost always recommend in the types of contracts that you will typically enter into is a short-term or a no-fault out, so that you're not looking for a breach or having to prove a breach, but rather without cause, with X amount of notice, which usually 60 days is fine. Something reasonable the other side can stomach as well. We can get out at any time. It's just a tremendous benefit and saves a lot of headache. It's not easy to show a breach, and you don't want to end up in arbitration or court as a result of it if you can get out with this sort of no-fault way. A lot of times you'll have contracts that will start with a rather short term and it all looks good, but the renewal term is on the horizon to like 5 or 6 years. I would obviously avoid that as well. I say it's hard to show breach, but you do want to provide for it in your contract. You want to define it well enough to show that this or that is actually going to be a breach of the agreement, such as failure to meet deadlines or failure to provide a product that's reasonably acceptable to the organization. The ability to get out of a contract, in my mind, is next to scope, probably the second most important provision to pay attention to. We've got some slides here to talk about managing contracts from a business perspective. I think they are pretty self-explanatory, so I don't want to kind of pull us into even later here. I'd be happy to answer any questions on it. But the idea here is that you need to identify, first centralize where your contracts are, make sure you know when expirations are happening, when automatic renewals are coming about, and also know at the outset what type of contract is going to require legal review and what is not. What type of contract is going to have a requirement of a signature at this level of the organization, director level, vice president level, et cetera, and make sure that those are adhered to. Use the form agreements that you have and try to make sure that all staff are aware of the process. So, these are some of the things we were hoping you would take away from this presentation. First, negotiate a contract that has some clear terms that address and manage your liability and risk. I'll be aware of when to push back and when to see that the terms from the other side are unreasonable and need to be negotiated, particularly on the liability limitation issues and the indemnification. On the meeting side, see how you can narrow your exposure on attrition and cancellation. And finally, look to how you can either re-examine or bolster your internal contract management process. So that's all we have. Happy to answer any questions. We'll be around for a little bit after the presentation here.
Yep. Thank you, George. Thank you, Audra. We're going to have to wrap up the presentation now. We'll, of course, stick around afterward for questions. And so for those of you on the webinar, if you have any follow-up questions, feel free to email those to me, and we'll be happy to take those. Thanks, everyone, for participating today.
Thank you. Please stand by.